Wait for you guys to tune in. Let me put my phone number in here in the meantime. How's everyone doing? Hope you guys had a good weekend. I was at immigration yesterday, USCIS, so I couldn't go live. The next few weeks, I am back to back at USCIS interviews with clients. So any day I can, I'll show up, but I've been very, very busy. Just 1 second, guys. I'm putting in my phone number. Good morning, everyone. Hope y'all are doing well. My name is Ayesha Chidole. I'm an immigration attorney. My office is in Atlanta, Georgia, but I represent clients all over the United States in all 50 states with their immigration matters. We handle family and humanitarian-based cases, removal cases, and detention, getting out of detention. If you want to schedule a consult with us, it's 678-325-1037 or 678-233-2170. You can also WhatsApp us at 404-333-8751. We don't take calls on WhatsApp, but you can message us there. But you can call us on the other numbers. If you're on YouTube or YouTube or Facebook, I'm sure you can see my number posted on there. I've pinned it for those of you on Instagram. I just want to jump right into the questions so that I can, kind of have a productive live. I've just been tabulating because, a lot of times I just kind of go over at a tangent or I'm answering the same questions, so I don't get to a lot of people's questions. So I have a few questions from people or that I keep getting asked. So I just kind of want to talk about them. And then if there's more time, I'll get to today's or add it to the next batch of questions. Okay. So one of the first and most important one that I want to talk about are for those who are filing VAWA applications based on being abused by their U.S. citizen or green card holder spouse. There's a common misconception or confusion about this and what creates eligibility for it. So really, the question is, can you file for VAWA if you never lived with your spouse? The answer is no. The answer is no. I know that many people are confused by this, or it's complicated by this, but I'm going to give you guys, a deep dive and a true breakdown of helping you understand this. So in order to file a VAWA application, because you were in an abusive relationship with your spouse, you must prove that you lived with your spouse after you got married. There was a time prior to December of 2025 where you could show you lived with them before marriage and or during marriage. But the current rules as of today, August in 2026, you need to show that you lived with your spouse at some point during the marriage. Now, is there a time requirement for how long you lived with your spouse or how short you lived with your spouse? No. But what is critical is this. You must show that you lived with that person. And even if it was a short time, that short period was with the intention that this was your new home. And for whatever reason or whatever happened with you guys, you ultimately ended up not living together. So what does that mean? It means that if I'm married to someone, I'm like, okay, I'm going to come over here on Friday, but I'm heading back on Sunday or whatever it is, that is not cohabitation. That is a visit. The funny thing is that in a visit situation, when it is a VAWA case based on a child filing against a parent, USCIS will count visits. But in a marriage case, they have to have some sort of evidence of cohabitation or that the period where you were in that house, you were an intended cohabitant, meaning that that was your intention while you were living in that household, even if it was short-lived or not. This is very critical, and the reason why I talk about this is because a lot of people often get this confused and think that they are still eligible. And I also want to speak about, sometime last year, somebody gave me one of the very rare 1-star reviews in our reviews or whatever it is. And, generally, I don't necessarily, talk about, as an attorney, you're precluded from discussing certain things or whatever it is. But one misconception from that review is that if you're married to someone in the military, that exempts you from living together. That is false and that is inaccurate. The only exemption that you can qualify for as a VAWA applicant if your spouse is in the US military is if you're able to show that yes, the abuse didn't happen in America, but that is because my spouse was working in the US military outside the country. We have represented people who filed for their VAWA applications while outside the United States, but their spouses worked for the United States government. That is, so you only get a military exception for the abuse, but not cohabitation. So again, if you are someone who is experiencing abuse, but you've never lived with your spouse, you will not qualify for VAWA. So I just want to make that clear because I know this is something that confuses a lot of people, and so hopefully that provides clarity for you. The other question that I wanted to address today was, let me see what this one is. This was a marriage-based case where the person said, we don't live together right now, and we are filing a marriage-based case. Is that going to hurt our case? The answer to that question is a very lawyer answer, which is that it depends. It depends on the reason why you're not living together. There are very many reasons why different people don't live together. But the reason has to be logical, because when I say logical, meaning you really have to explain your reason. We recently got a client of ours an approval, I want to say last week, and someone from one of the 39 countries. And as a matter of fact, both spouses lived in the same state. They lived in the same state, but different addresses, right? And we were able to document, and this was one that I spent time trying to ensure that anyone reading this application will understand the reason why. Because again, understanding and simplifying this helps an officer to understand the reason why. Because sometimes, clients will go to an interview and they're not necessarily the best at articulating or explaining the situation. Where in this scenario, the reason why they were living apart was because one person had gotten a job, which was going to be starting in 2 months in a different city. And the other person had a rent-controlled apartment, which she would never be able to get, the cost of it, if she moved to another place, knowing fully well that her husband would not even be in that location because he was moving away to in 2 months' time. So it didn't really make sense. So because of that, what we did was we provided proof of that job. It was based on a program where they couldn't refuse because it was part of a post-baccalaureate degree, a PhD program where they had to continue. So we had to provide evidence of that. We had to provide evidence of the rent controlled. This is how much would have been here. This is how much would have been here. This is what the salary would have been. This person wouldn't have been here. And this is only for a temporary position for a year and a half. So she can't leave that rent controlled place, uproot her life, go over there, and then have to come back and pay ×3 based on her income. But the thing is documenting the reason why. A simple example, you filed for, you're working here on an H-2B. I know a lot of our audience come here on an H-2B, and the H-2B is in I don't know, Utah, and their spouse, let's say, lives in New York and has a stable job in New York. In that case, if we can document that this H-2B program is temporary and this H-2B program ends on X date, and I don't know if I would continue another job there. I'll get a job offer there. It makes no sense for the New Yorker who has a stable job for our life and family to uproot herself to this temporary job that ends in a year without us knowing if that person will get a job there. So it makes sense that when the person with the H-2B finishes or gets their status, then they can decide whether that person is moving to New York or where they're moving to together, because the person with the H-2B doesn't want to violate their status by quitting their H-2B job. Again, these are examples that make sense. Examples that don't make sense is, well, yeah, we live in the same city, maybe we live like 20, 30 minutes apart, but I just don't like his apartment. I don't like her apartment. Or she lives with a friend, so I don't want to do that. Like, those reasons are not good enough. Like, those are not good enough reasons. When you have reasons like that don't make sense why you're not living together, those are the things that will cause you to be denied. So if you are filing a marriage-based case, this is specifically for marriage-based case, not VAWA, because remember I just told you earlier, with VAWA, you must show at some point during marriage that you lived with your spouse. In a marriage-based case, if you didn't before you filed a marriage-based case, you must show why. Now, if let's say y'all just got married and you're just filing a quick application, you just got married, I want to get this out, I live in New York, this person lives in Maryland, or whatever it is, the goal is that you have to proactively show that you're planning to move together. So what do I mean proactively? Apartment, that you guys have been looking for apartments, you've been looking for jobs, job application evidence that you've been applying for so that you can quit your other job and move, and stuff like that, or whatever. Like, so those are things, with that, you want to have other really solid bona fide evidence of your relationship, so that becomes secondary. So that's that on marriage. Okay. Someone is asking, how can I contact you directly? You can speak to me directly by scheduling a consultation. A consultation can be scheduled by calling our office, which is on the profile right there. It's 678-325-1037. You can request a consultation with me. Or any of the attorneys that work at my firm. They are all equally as capable in assessing and analyzing whether you're eligible for something or any potential red flags and whatever it is that you're trying to file for. Sometimes myself or any of the other associates, we're very busy, so it's not like I'm just like sitting down and twiddling my thumbs and I don't want to, meet with people. Like, some days, like, I might be in USCIS for like 4 hours or 5 hours. Like, if I have a back-to-back interview, like I have one coming up next week where I have like back-to-back, like 3 interviews back-to-back. So sometimes you might have to speak with someone who's available, or if you're patient and you want to wait till my availability, you can also do that as well. Okay. If you are one of my clients, it's the same way. You request a meeting with me through your client portal, it must still be scheduled. Okay. So you can either send an email, but preferably you can use your client portal, to schedule one. Okay. Okay. I'm a VAWA approved person, but my I-485 is pending. I record in April, I submitted my medical. So mostly, when can I expect to get a green card or any response? I don't know. But right now, I would say that it might take up to a year. And most likely you will be scheduled for an interview because they are interviewing every VAWA applicant right now before they approve the case. So because of that, you will have to wait until you are scheduled for an interview. So that would depend on your local field office's availability or whatever it is. But we're seeing from when people send their medical to when they're being scheduled, about a year. Okay. Okay. Another question that I got was, will USCIS question my marriage if it's the second marriage for both me and my spouse? The answer is not necessarily. So it really depends on your both previous marriages, whether you're applying for immigration or not. People divorce, people remarry. And that doesn't mean that any second marriage is not a good faith marriage. Some of the things that you want to think about, if you are in your second marriage and your spouse is in your second marriage, is you want to think about Well, when did you get divorced versus when did you remarry? Were you guys dating while you were still married? Did the person file for someone else, or did someone else file for you? And what happened? So these are just things to look through and make sure that you're able to address, but more importantly, and the most important thing being at the end of the day is, do you have a genuine marriage? Whether or not it's your second marriage or third marriage, do you have a genuine marriage? We have someone that's the president who's been married 3 times. Doesn't mean that any of his marriages are not genuine. So people marry, divorce and remarry, but are these marriages genuine? That's really all it boils down to. Okay. Okay, let me see what else. How many prima facie determination letters do you need to receive before you get approved? There is no fixed prima facie determination letters that you need to receive to get approved. Prima facie determination letters don't determine whether or not you're going to get approved. They just determine prima facie eligibility. Typically, when you submit a VAWA application, if you are prima facie eligible, you will get a prima facie determination. And for many people, or for many states, that might come with benefits, which include financial aid to go to school, assistance with housing, or to get out of your domestic violence household and get somewhere else to live. In some states, a driver's license, but it depends on the state. I can't speak for all 50 states. So you want to check what the requirements are in your state. So now, that said, the first prima facie determination letter you get is for 1 year. After that, they're going to automatically, you don't need to reapply for it. They are going to automatically renew it for 6 months, 180 days, in 180 days increments. And they're going to keep doing that until they make a decision on the VAWA case, which is the I-360. If they approve the I-360, then you're done getting prima facie determination. So that's how it works. Someone is asking, is filing tax married filing separately considered as evidence of extreme cruelty? No, this is not considered as evidence of extreme cruelty without more. If you're saying that you're filing it because your spouse controlled finances, they refused to file jointly with you because they were hiding something, that there are other things that they do to control finances or not kind of give your voice to it, maybe. But people file married filing separately for different reasons, but it's not really a basis to say someone is abusive without more. So there has to be more. Okay. Okay, let's see. Can you qualify for VAWA if you were never physically abused? Yes. There are many different forms of abuse. The National Domestic Violence Hotline, or website usually will list different forms of abuse. If you're someone who is not sure if you've been abused, but your spirit feels that you've been abused, that is a good place to check. Also, you can check with consulting with an attorney so that they can evaluate what's going on with you. You can check by consulting a psychologist, a psychiatrist, a doctor, about what's happening in your marriage. There's so many forms of abuse people experience, which can include psychological abuse, verbal abuse, which leads to emotional abuse and mental abuse, because a lot of times verbal abuse is to pierce your soul and to pierce your spirit, which basically affects you mentally. So they kind of go hand in hand. Sometimes there's sexual abuse, okay? Sometimes there's physical abuse that doesn't include punching and slapping. Physical abuse is you leaving your child or your spouse in the household because you're angry and refusing to turn on the heat in a cold winter night and having control of it. And these examples I'm giving are real life examples of people that have experienced, where they left the house for 10 days, refused to turn off the heat or pay like the whatever bill. And those kids, his three kids and his spouse were left in the household at like 20-degree weather, right? Freezing as a way to punish her, right? For speaking up about certain things, like, so even though there's no punch there, but that is physical abuse because they could get sick, they could get pneumonia. This can kill people, right? Or leaving the household and abandoning your spouse, knowing fully well that your spouse relies on you to support them financially because they don't have their paperwork and there is no food in the house. They don't have access to a car. They don't have access to money to get an Uber and find somewhere else to go to find food. They have to call friends or family to see who can send food to their address. That is a form of physical abuse that doesn't include punching or slapping. So I hope this is helping you understand that there's so many nuances and so many things that, people experience that they don't even realize how bad it is until they speak to someone and they say, no, 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 no. This is not acceptable. There is abuse of the legal system where any fight or argument, the person picks up the phone. All right, say one more word, and I'm going to call ICE on you. Say one more word, and I'm going to call immigration on you. Say one more word, and I'm going to call the cops, and I'm going to tell them that you scratched me. Better yet, let me scratch myself, and I will call the cops, and I will tell them you scratched me because I'm female, or because I'm a U.S. citizen, or because I'm white. They will believe me. These are all real life examples of people that we've represented. So like, I'm not even making up random stuff. I'm telling you of real life examples of people that we've represented and what got them over those humps where different things like that happen. So there's just so many things that constitute abuse. There's technological abuse, sometimes even tied in with emotional abuse where people go online and shame their spouses, post things about their spouses to the public or to the people on their social media to shame them, or people send text messages of like somebody else's manhood and says, I wish yours was like that, or whatever it is, or you'll never be as good as my ex, or you suck, at this. Or telling, their wife, why don't you have bigger boobs? Go get surgery. I had someone nearly on her deathbed getting a BBL, to keep her husband there. And he still was cheating with multiple women and eventually gave her like chlamydia, So again, which is a form of physical abuse, like, sexual abuse tied into physical abuse. So as you can see, some of these abuse, like it's not one size fit all. Like, abuse is really complex and they tie in together, so, but the only way to really know is to really understand your story. Like I would say, like with VAWA cases, one act of infidelity, like, okay, my wife cheated on me, one time with this person, or my husband cheated on me one time with this person, is not necessarily extreme cruelty. But what we're looking at and what officers are looking at is a pattern of behavior that it's just too much. It's like any normal person will be like, enough already. This is just too much. You know what I'm saying? So that's how you look at abuse. I got to jump off, but someone is asking, what kind of question can they ask in an I-360 interview? A lot. That is not even, I can't even scratch the surface of that in a live session, unless you're my client and we're prepping, and I'll go over some of the questions to expect. These I-360 interviews last anywhere from like 2 hours to 3 hours. Some people have heard 4 hours. I would say for me, the most that we've had, like with our clients, maybe like 2.5 hours. But I also know people who have sat in there for 4 hours, especially if translation, like you need an interpreter, because by the time this one answers it and moves on to the next person, the officer has to type all the oral statements. So it's a lot of questions that they're asking. So do not take that lightly. And then one more thing that I wanted to talk about, and I got to jump off, is that as you guys have seen, USCIS is wanting to start mandatory filing of certain petitions that have been have had an online option for at least 180 days. They haven't finalized it, but this is a really good time to make sure that if your petition requires an online filing, that you are filing online. Obviously, if you're using an attorney will file it for you online through their portal. But also, I think this is to frustrate people who don't know how to use a computer, who don't know how to, figure out how to set that up or whatever it is. I've said it before, whether it's me or not, you're hiring. You should really not be applying for immigration right now without the assistance of an attorney. I don't care how slam dunk you think your case is. Like when I tell you that it is crazy out here in the streets, believe you me. But whatever you decide, just make sure that you know whether your petition requires an online filing, and you're making sure that you're getting used to that. And as a reminder, September 18th is when the new public charge rule and forms will start. So you want to make sure that you're cognizant of that, and in ensuring that if you are filing after that date, that you're eligible to file. If you're eligible to file now, stop dilly-dallying, file now, make it easier for yourself. All right, guys, I got to jump off, but I think tomorrow I might have a break from USCIS, so I might be on live tomorrow. I'm not sure, but if I am on live tomorrow, it'll be at 10 a.m. Tomorrow morning. I hope you guys have a great day, and I will talk to you